Good morning, ladies and gentlemen. We are individual law consultants who are hired to give advices for our firm's clients. In this presentation, we would like to discuss a couple of cases which involves contract laws and corporation law, as well as to give advices and explain the rights for our clients according to the common law and statute law. The first case will be presented by myself and my colleague Aisha. The second one will be discussed by Chi and Tong. To begin with, I'd like to provide a quick brief on the case.
According to the given topic, Alan and Jane entered into sale contract of the travel agency sold by Alan to Jane. As the contract has been formed into legally enforceable agreement, each party should have their own liabilities in fulfilling the requirement of the contract. Under common law, the contract between two parties will be completed by the completion of each party's obligation, in which Jane has been successful in buying back this business from Alan to operate as the new owner of the business. However, in this circumstance, the business turnover after some months is only half of the amount representation statement made by Alan. Therefore, Jane must rely on the contract law to seek remedies, in which she is the plaintiff and Alan is the defendant in this case. In order for Jane to successfully make a claim for the financial damages caused by the contract she entered with Alan, we need to rely on the contract law of the Corporation Act 2001 and its relevant cases, which will be discussed in detail below using the IRAC method. Now the issues is there a legally enforceable contract between Alan and Jane? If there is a contract, what are the liabilities of both parties? And what elements can Jane rely on to gain the contract void and remedies from Alan? Also, what elements should Jane consider that will be used against her in the court? The rules here are the Corporation Act 2001, the contract law, misrepresentation, Australian consumer law, and the relevant case law. Now my colleague Aisha, she will be talking further about the analysis.
According to Corporation Act 2001, there are three elements which must be satisfied to prove three valid contracts. That is agreement, intention to create legal relationship, consideration. Intention to create legal relations. In this circumstance, both Alan and Jane showed their intentions to enter in contract. Jane accepted the offer by agreeing to pay $500,000 to Alan to obtain the ownership. For that consideration, there is a consideration both parties that the contract for sale made no provision to the earning capacity to the business. In order Jane to sue Alan for his misrepresentation, Jane must prove three types of misrepresentations, that are fraudulent misrepresentation, innocent misrepresentation, and negligent misrepresentation. In that conclusion, I want to say Jane could not rely on contract law to sue Alan for his misrepresentation, but must rely on Australian consumer law to seek possible remedies for statutory law. Thank you.
That would be all of the advices that we'd like to give our client. Now I'd like to invite my corporate law colleagues to continue this presentation.
Right. Thank you very much for your presentations, ladies. So apart from that, we also got a client asking us about advices.
So to begin with our part, I would like to give you a quick brief about our case we just received. Adam is representative of the Master Play Company, and he signed the contract with Irish Linen Company before his company registered. Adam and Paul are two directors of the Master Place since 24th of February. After registering, Adam also signed the contract with Cover Limited for the cutleries. So to come up with the legal issue in this case, which are to determine the liability of each parties in the case, we need to rely on the elements of corporate law under Corporation Act 2001 of New South Wales and all of its elements. We need to assess the duty of each director under the Corporation Act to evaluate their capabilities and authorize when entering the contract with Covers and the Linen limited companies. The detail of each issue will be discussed in the detail in the application part according to relevant section of the company law under the Corporation Act 2001 of New South Wales and relevant case law of Australia. As we mentioned before, there are two major laws that we need to consider in the case, including Section 131, Contract Before Registration, and the second one is Section 127, Execution of Document, including this by the company itself, and relevant cases laws.
Thank you, Queenie, for that. To continue, I'd like to give you the application in this case. So which means how we apply the laws in this particular case. So first of all, the contract must be signed before the company is registered to be valid in these sections. The company, which is the Master Plate Limited, would be bound by the contract terms and conditions and entitled to the conditions of the contract. If the company ratifies the contract after it is registered within the given time by the parties to the contracts. So that's the first conditions. Or with a reasonable time frame if there's no time was agreed on the contract. That's the second one. However, according to the given informations, as there is no time period required by Irish Linen on Master Plate to be officially registered and to ratify the contract, so the registration and ratification of Master Plate on the 24th of February and 30th of March after the contract has been signed on the 18th of February is valid, which satisfy the requirements of Section 131 of Corporation Act 2001 New South Wales under the pre-registrations contract. To conclude, we can confirm that there's a legal enforceable contract in this case between the Master Plate and the Irish Linen Limited Company, which require Master Plate to pay for the deliveries and the of the tablecloth under the contract law. The failure to pay the supplies will enable the Irish Linen to seek the remedies and recover the damage under the subsection 2 of the Act. To give some reference to to how we conclude that, refer to the case between Commonwealth Bank Australia versus the Australian Solar Informations Limited Company in 1986, or which will be referred in the written documents. Also, another case will be the Artec Science versus the Alanda Aerospace in 2005. Also will be written on the documents. The second part that we like to discuss about this case, that we gonna apply the Section 127, the execution of documents, including this by the company itself. So first of all, the law requires documents signed with common seal should be witnessed by first 2 directors of the companies, 2 a director and a secretary, 3 sole director who also acts as a sole secretary. So in this case, Adams is not a sole director and the company does not have a company secretary. So Adam could only enter into the contract with cover by using the company's common seal with the witness of Paul as the second director of Master Plate. However, in this case, the contract is still valid and act at a D without the affix of the common seal in the case law, which will refer to the Hewlett Packard Australia Limited versus the Exit Limited in 2004. So after discussing the 2 sections of the corporate laws, we come up with a conclusion that both of the contracts entered by Adam are valid. They are legal enforceable agreements or legally enforceable contracts, which both parties need to follow.
So that's how we conclude the case. So that's the end of our presentations. We would love to hear some feedbacks or advice from you. Thank you for the time.
Thank you.
Thank you.